Hey guys, it's Ripped Off and Pissed Off coming back at ya. I have been bogged down in body corporate regulation and acts and all kinds of stuff, but it seems our conspiracy theory gets deeper and deeper and deeper. So I'm going to start today with the difference between the two models that we discussed last time. There was the regular model and the accommodation model. There are other models available, but these are really the two major ones that affect majority of strata or body corporate living in Queensland. So we worked out originally that the regular one had less regulations than what the accommodation one did, but I wanted to go through it all and work out what the major differences were. And it seems that the regular model has no requirement for there to be an actual manager on site in the complex. So the theory there is that the majority of the lot owners are living in their lot. So therefore there doesn't need to be someone on site to show lots or to have a letting contract at all. If there's a smaller percentage of owners that are investors, then they can get property management elsewhere, and there's no need for the majority of the complex being owner-occupiers to be paying for something that they don't need. So I thought that was very interesting. And the accommodation lot, obviously, because the majority of the lots are for renting or holiday renting, depending, Gold Coast, depending on where they are, then of course there is the requirement for the letting manager to be there to receive new tenants, to interview new tenants, to show units, that sort of thing. So they seem to be the major differences between the two as far as it affects the lot owners. The other major difference between the two is the length of the contract, and that's when we start getting to the conspiracy theory. So before we get to that part, which we'll get there, believe me, I thought to myself after reading that, why hasn't the body corporate management company told us that as lot owners? Because we as lot owners, and I'm sure you'll agree if you're a lot owner, you see the body corporate management company as the expert in the industry. They're the one who knows what to do. They're the one you call if there's a problem. They're the one that are doing minutes and stuff for the committee. So you would think that they're the ones that are in the know. So I decided to see if I could find out if there was an actual definition for what their role should be. But it seems it depends who you ask. So I went back to mybodycorporatereport.com, which is a wealth of information I'm finding. And that website says that the term body corporate manager refers to both a qualified industry professional elected to have a solid grounding in legislation and industry practices and property management. So that's a fairly straightforward definition. They should be the expert. They should have the information about the legislation, etc., you would think. And then I came across a very interesting article from a website called Commissioner's Corner, which is the Commissioner for Body Corporate Services. And this article was dated the 13th of June last year. Dated the 13th of June last year, and titled Strata Managers' Role and Misconceptions in Queensland. And it states the management company's duties to be admin, carries out the admin duties agreed, prepares drafts and budgets for financial statements, etc., doesn't have any decision-making power, it places and pays for the insurance, it maintains records of the complex, it distributes correspondence, and it prepares the meeting material, which is about what our strata company is doing. But at the bottom of this section on their website, there's a disclaimer. And the disclaimer ensures that we understand that the points do not intend to cover everything that the strata management company is supposed to do. Fuck? What the fuck? Aren't they the expert? Aren't they supposed to know everything? Why would they leave things out? Because they're hiding something. You don't leave things out unless you're hiding them. So then I went to, I did some more Googling and searching and that sort of stuff, and I found an article, this time by the Unit Owners Association of Queensland, and it's titled The 10 Rorts of the Body Corporate and Community Management Act, Queensland, 1997. So obviously I thought that was worth a read. And it defines the body corporate management company's responsibilities as being dealing with correspondence, handling questions and phone calls from the lot owners. Now this is the one that is the important point. Liaise and advise committee members on matters of legislation and best practice. It goes on to say issue the notices for the meetings, issue levy notices, drafting contravention notices on behalf of the committee, overseeing the bank account and making the payments for insurance, etc. So all of those parts seem to be the same, but this article indicates what I would have thought, and that would be that the body corporate management company advises the committee on what is the legislation, but what also is the best practice for our complex, because the committee aren't body corporate experts, and I've been doing this research now for a week, and I'm a layperson. I'm just an angry owner who is sick of going around in circles trying to find out how I can get this situation changed, or someone to listen to me about how ridiculous this is. And it seems that I'm probably not the only one, because I can't see how committees know any of this stuff. If you're working full-time and you've got a family and you happen to go on the body corporate committee because you care about your property, you're trusting what the body corporate management company is telling you, because you don't have hours and hours a day to sit down and research this stuff. And I've spent anywhere from 2 to 4 hours each day trying to find this information online. So it's not an easy task to do, and it's not something that a lot owner would believe that they need to do, because they would believe that that's what the body corporate management company is for, because there is the indication or the connotation there that they are the expert, they're the industry expert, and they're going to advise on what's best for the complex, because the body corporate company or the committee are paying them to do this. So I would tend to agree with this gentleman, and I would wonder why our body corporate hasn't mentioned to us the difference in the title modules, or why we haven't been changed over to that when the needs of this complex changed. So I am trying to remember where I was up to. Okay, so yeah, it depends who you ask as to what their responsibility and duties are. And if you ask people who are using the system, then they should be doing more than what they are. If you ask a government or real estate or the strata management industry, then they're doing exactly what they should be doing. So if they aren't seeing the recognition for the need for change here, then there's obviously money in it for them as well. So I decided to have a look at an article, go further into the article of 10 Rorts of the Body Corporate Management Act. And this is what this gentleman states are the 10 rorts of the Act. So first is 10 and 25-year caretaking contracts. Number 2, the inability to terminate these caretaking contracts. The Body Corporate and Community Management Regulation Accommodation 2008 Section 3. Number 4, the assignment of management modules. Number 5, the Body Corporate and Community Management Act 1997 Section 180.3, no letting choice. So I'm assuming that means if you are an investor, you don't have a choice. If there's an on-site manager, you have to use them, which seems to me to be unfair practice. But anyway, that doesn't affect me. Let's keep going. He also talks about the Property Occupation Act of 2014, which was when the real estate industry was deregulated, or they separated the Motor Dealers Act and the Real Estate Act separately, and there were tighter regulations and more paperwork put into place because I was working in real estate at the time. So obviously there's something in there. I've never done commercial real estate, but there's obviously something in there that is not good. Number 7, there's the local government. Apparently for investors, there's a utilities and a view tax if you have a investment property. Number 8 is building insurance kickbacks for the Body Corporate Management Company. So there's part of the money because they're getting kickbacks when they're referring your insurance to the person who's giving them the biggest kickback. So that seems, I thought they outlawed that stuff like ages ago. Number 9, banking arrangements are not in favour of the body corporate. So that would be the lending, I would suggest, that we talked about a couple of videos ago, is that there's only a certain number of years that a bank will lend on. If it's under a certain number of years left to run on the management contract, the bank just won't lend on it. So I think that's what that is referring to. And then point number 10 says that there is reward for poor conduct on termination of a letting or caretaking agreement. So there are a few points there that are of interest to us. I think the first point is the contracts, the length of the contracts. So it says here that the purpose of the 25-year contracts is simply capital gain. That's it. It's about money. The contract will escalate by a compounded CPI over 25 years. And this doubles the caretaker's salary, costing unit owners millions, obviously, every year. 25-year contracts allow caretakers to make capital gains of 5.5 times the annual profits via goodwill when the contract is sold. So it's about buying and selling, in and out, and making money. The average caretaker contract in Queensland is sold every 3 years. So this is where I think I'm having the issue, is that I'm thinking that they go, oh, it's all too much and I don't want to do the gardening, but it's not. It's like get in for 3 years, deal with the complaints, hide as much as you can, then get out and make a whole bunch of cash. While all us lot owners have got like a revolving door of caretakers where we're not getting any service at all. Number 2 is the management rights are too valuable as an asset to the caretaker to be regulated in any manner. So that seems a little bit antiquated to me, is that one guy is making a whole bunch of money, so we can't regulate that industry. I just don't see how that makes sense. So as this guy says, that's like 2008 thinking. And there was a really, really strange judgment or strange ruling made by a judge that management contracts could not be terminated because they're so valuable. He also stated that property developers want to be able to sell the management rights for large sums of money. And the rights, while they're still under the control of the developers, need to be really a secure perspective for proposition. Proposition for these new managers. Otherwise, they're not going to be prepared to pay what the developer is hoping to get for that management right contract, which I'm assuming is to recoup some of his costs from the development in the first place. So again, this is all about money and has got nothing to do with the actual people that will be living in these complexes. So number 4, the Department of Justice and Attorney General's interpretation of the allocation of the standard and accommodation models is contrary to the understanding of the Unit Association of Queensland. So again, this is all about who you ask. And the person that you ask will give you the interpretation which best suits them. And that's the problem here. Everyone is doing what best suits them. But when you live in a complex and it's a community, there are certain issues that need to be not just about one person or one person's profit, but about every person's profit. Because currently, I'm convinced that my property value is plummeting, and I'm going to do a video about that as well, because of the state of this complex and the astronomical body corporate fees. So if I was a potential buyer at this stage and I came to have a look at this complex, and then I looked at the body corporate, the caretaking fees were close to $3,000 a year, I'd be like, $3 grand for this? No way. What? And it goes up 5% every year? How is that an attractive prospect? It's not for an owner. Or even for an investor, that's not an attractive prospect. The only person who that is attractive to is the bank and the on-site manager who's trying to get in and out within 3 years so he can make money. The conclusion of the article is very interesting too, I thought. It states that the one consistent loser from the Body Corporate Management Act is unit owners. The legislation tears at the very fibre of Australian democracy. If the unit industry in Queensland is to flourish, the Body Corporate Community Management Act must be dragged into the 21st century and legislation amended to reflect democratic values and to reflect what today's housing needs are. Whether the government or the developers or the on-site managers or the body corporate companies like it or not, the housing market is such that most of us, to get our foot into the housing market, we have to come into these complexes because we can't afford to buy a house that is a standalone house. The price of real estate is ridiculous. So more and more people are buying because they want to live here, but they're not getting treated like owners that live here because there's no financial benefit in that for body corporate companies, for governments, for developers, or for real estate agents, or for on-site managers who want to make a fast profit. So I also found, which I thought was really interesting, a submission paper from 2012 where the Justice Department has recognised this frustration between strata management and on-site managers and lot owners, and that lot owners are completely dissatisfied with the current system. And he talks in here about all of the things that we've been talking about, and there was a submission date, so people could do their submissions. Now, I didn't know that this was happening, and I know that 2012 is a while ago now, but do you have to go searching on the net to find this stuff? Or if there's a review of the body corporate legislation and the body corporate management companies got to know about this, why isn't this going to the committee? Why isn't this going to lot owners? Isn't it their job at least to disseminate that information, even if they don't want us to have too much information about it. Like, I don't understand. We're being kept in the dark, it feels like. And we throw our hands up. I threw my hands up ages ago and ignored the whole thing until my garden started to die. And then when the Commissioner for Body Corporate Services minion told me if I didn't like it, I could sell and go live in a house, then I really got my dander up. And then when you get into this stuff, it's ridiculous. It's absolutely ridiculous. And there is no way that a person who is just a layperson living in a body corporate scheme, going about their day-to-day life, working, kids, all the rest of it, has got the time or knowledge to understand any of this. And I'm a layperson, so this is like really brief stuff. A lot of it I struggled to understand because of the legal jargon. So something's got to be done. It's not a new problem. It's not a problem that is isolated to me and my complex. It's a problem that is about the whole state, because there's no other state in this country that has these type of laws. And everybody's getting rich off lot owners, from what I can see. So I've decided that I am going to make an appointment to go and see Mr. Rossbaster. I did write to him, but of course it takes ages for politicians to write back to you. I have heard a rumour somewhere, and I am struggling to find it online, but that the Body Corporate Management Act expires either at the end of this year or early next year. So that means we've got a real opportunity here, if the Act is expiring, to affect proper change. If we as lot owners stand up and yell, because we're in the dark, nobody tells us what's going on. So I'm trying to get the word out there. If you are a lot owner, if you know someone that is a lot owner in Queensland, even if you are not a lot owner, you're not in Queensland, but you think this is BS. These people need a proper system, and in this day and age with a housing affordability crisis, we need someone to look at this. This is just ridiculous. So please, share. Sign the petition. If I can get 100,000 signatures on this petition, I can force Rossbaster to discuss this with Malcolm Turnbull. So please, you don't have to do anything. The website for the petition will not take your details. I will not spam you. I will not contact you. I will not harass you. I just want your name so I can present the signatures. Please. I'm begging you. Please.